Well, we're definitely contemplating that issue in respect of Chief Justice Gertrude Araba Esaba Saki Torkornoo jumping into the legal battle herself, filing for an interlocutory injunction at the Supreme Court to halt that ongoing process to remove her from office. There have been two interlocutory injunctions thrown out so far, one by a 3-2 decision, and yesterday, another one in a 4-1 decision, also dismissing the application. But hours after that, there was a fresh suit in the Apex Court. This morning, we're going to look at the twists and the turns of a Chief Justice seeking justice. We hear from some legal luminaries. First, joining the conversation, we have Kweku Paintil. He's a lawyer. Kweku, good morning.
Good morning.
It's good having you join this conversation. It's interesting because when we started off this conversation in the initial stages, you had quite a number of thoughts. Just for now, since you are the first to join the conversation, what do you make of how things have developed so far?
I would say it's very interesting. It's very interesting, and they're welcome developments. I mean, I think it is for the enhancement of our constitutional theory, development, application, whatever you want to call it. In other words, I believe that to deepen our constitutional democracy. Right. That's what I think of what's going on now.
Okay, so it will deepen our constitutional democracy. There are a number of issues that have come up on the back of the two suits that the Apex Court did not reason with the suspended Chief Justice on. But if you look at this third one and the reliefs, the remedies that are sought, about 16 of them from the chambers of Godfrey Adame, what do you make of that as well?
Oh, I consider them very interesting, very challenging, and very engaging, because it is actually an attempt to get the Supreme Court to reflect upon our Constitution at the time that it was made, developments that have transpired thereafter, and whether the Constitution must be steeped in the grounds of 1992, when all these issues of internet and diverse information, wherever, was hardly an issue. And now, when you file a process, it is transmitted worldwide. And against the background of the supposed secrecy that processes and proceedings in the courts were supposed to be conducted, against now that you file a process, everybody hears whether indeed there's a continuing need or justification for us to bind ourselves with the constitutional dictates or the requirement which intended that certain things must be done in utmost secrecy until the outcome or the results or the judgment. So that's the issue that is really now engaging our attention, whether there's a justification for anybody insisting that things must be done in camera, when before the camera hearing, everybody knows what is outside. It's a joke. I mean, that's my view. It's a complete joke for us to pretend that in the era that we find ourselves, anything can be done in secrecy at all.
That anything can be done in secrecy, but just because you made mention of that point, what does the Constitution say?
No, the law is clear, at least it's found in the Constitution. I'm not quoting provisions and whatever, but I'm very familiar with these things, that this type of proceedings ought to be heard in camera. And by camera hearing, it means that beyond and besides the persons and the judges who are directly involved, nobody must see the processes, nobody must comment on the processes, nobody must have a way of knowing what is going on, kind of. But that's very funny if you just oppose it into this, realities.
So do you think the existing realities, just before Sweetie comes in, the existing realities would be conducive for a public hearing of this nature?
I believe so. I honestly believe so, because everything is out in the press. Everything. Everything. So therefore, the pretense or the attempt to have an in-camera hearing is a joke. I mean, it's a joke. It's something that we are all pretending about. And I honestly believe that the request by the Chief Justice to have this matter heard, for everybody to know what is going on, to bring out into the public domain everything, so that at the end of the day, justice is for the people and by the people. Justice is for them. Everything that we do in the court is intended to buttress and to deepen their faith in our democracy. And indeed, I mean, the traditional rule against public hearings, where in matters that affect public decency, in other words, I mean, sexual, whatever, suits and the rape and things like that. But even now, judges are hearing some of these things in the public. I mean, everything has changed over time. And I think that at the time that the 1992 Constitution, we may go back to 1992, see the background from which we came from and all of that. And in 1992, I don't even know, I don't believe 1992 was an adult. I don't believe there was anything called internet. I don't believe there was anybody who contemplated, anticipated that time is going to come that anything can be broadcast from America to Ghana through, text and stuff like that. So, to the extent that we have a constitution that captured the events of 1992, it's about time that we told ourselves that any attempt by anybody to hold on to the forms and the substance of things in 1992 is a big joke. I mean, that's the long and short. And I understand Dami's application to reflect this sentiment, this feeling, that it's about time, even if the Constitution said it. Everybody knows what is going on. Everything has been published. Look at the commentary. Indeed, as a matter of law, even all the publications that the people are making, it's against the constitutional provision itself. So what is the pretense? I mean, why do we say that these things have to be done in camera when everybody is commenting, everybody is talking about it, when even matters that are in court traditionally, they are not for public discussion, they are not for public commentary. So what is it that we cannot do by not hearing this matter in public?
It's interesting. People will stretch it and ask you to what extent can't the public discuss it and what exactly are the stipulations of the Constitution. But sweetie.
Yes, and Mr. Pencil, I mean, aside that one demand for in-camera hearing or not, a lot of arguments pouring in suggest that the Chief Justice's move to go to the Supreme Court backed by lawyers is a, quote, provocation. And I'm quoting former director of Ghana School of Law, Kweku Ansasari. He said the move is a provocation that flies in the face of constitutional governance. To which he's saying that she should have gone to the Judicial Council, not go to the Supreme Court backed by lawyers. Help me understand what's going on here.
You know, I found Kweku Ansasari's commentary very interesting. I mean, I find it very interesting. You know, life is dictated by circumstances, by things that are going on. And I don't even understand Kweku Ansasari's position at all. Because her office is at stake. It is true we've got a General Legal Council that has got a way of resolving matters. But this is a case where the president has made moves that are intended to remove her from office. When the president has invoked that power of his under the Constitution, which may lead to her, removal from office, I'm sorry to say that if Kweku Ansari's argument is to suggest that the Chief Justice ought to go to the General Legal Council, I fear that there could be no legal basis for his suggestion at all.
In fact, he joins us on phone right now, and so let him respond to what you just said. Mr. Kweku Ansasari, thank you for joining the conversation.
Yes, madam. Welcome. Yes.
Is that Mr. Kweku Ansasari?
Yes, please.
Okay, we were just discussing the statement you made, I believe, yesterday on PM Express, describing the move of the suspended Chief Justice to go to the Supreme Court backed by lawyers as a provocation that flies in the face of constitutional governance. It doesn't appear Mr. Pencil agrees with you. Who just dropped the line? Oh, unfortunately, Mr. Pencil.
I am on it.
Mr. Pencil, go ahead. I wanted him to respond to what he just said, but he's dropped the line.
I really wish that he could defend his position with legal arguments. But right. I can only say that the Chief Justice has not committed any error, whether in procedure or in substance, of the law when she invokes the jurisdiction of the Supreme Court to make a determination on what the president has initiated against her. If at all, at the end of the day, when the Supreme Court delivered itself of its judgment in this matter, if for no reason at all, to serve as a precedent so that to guide us all, or to guide all of us as to any future course. Don't forget that this is the first time that there has been any move under the 1992 Constitution to remove the Chief Justice from power. And therefore, as far as the legal precedence is concerned, within our jurisdiction, I would say that it's without precedent. But what happens in what's going on will serve as a great lesson for all of us. So for that reason alone, I think that there is some basis for the Chief Justice's action.
Okay, and Mr. Pencil, that's a great point to land because we have Mr. Kwaku-Ansah-Asare back online. So, Mr. Kwaku-Ansah-Asare, Mr. Pencil disagrees with you. Your response? Good morning. The question is, you said that the Chief Justice should not have gone to the Chief Justice's move, going to the Supreme Court backed by lawyers, is a calculated attempt to frustrate the committee's work. Mr. Kwaku Pencil disagrees with you that there's no basis, there's nothing wrong. The process that the Chief Justice has employed so far, there's nothing wrong with what she's done. So help us understand your point. What you are calling a provocation that flies in the face of constitutional governance. What do you mean by that? We cannot hear you. Please unmute if you are muted.
It appears we're struggling with a connection to Kwaku-Ansah-Asare. It would have been interesting to get what his thoughts are, especially on that issue of sort of triggering the committee that has been set up. But coming to you, back to you, I'm sorry I'm belaboring the point. If you look at the initial bid in respect of an in-camera hearing, is there any breach specifically? Kwaku Pencil, just give me a straightforward answer. Per the Constitution, is there any breach?
Any what?
Any breach of the law?
No, I wouldn't say so. You know, these matters, this is not the first time that a matter affecting in-camera hearing has come up where the public have already entered into the debate and so forth.
Right.
I was trying to recall one of these two cases, but I remember Justice Benning. He had delivered one of these judgments in which an attempt has been made to set aside the proceedings on the basis that the public had already determined the matter had has prejudiced the hearing and determination. And Justice Benning, I'm sorry I cannot remember the exact case, but I remember this is not the first time.
Okay, Mr. Pencil, I'm sorry I have to interject. We're trying one more time to reach Kwaku-Ansah-Asare. Good morning, sir.
Good morning.
Okay, I can hear you, but faintly, but it's okay. Why do you feel that this latest process, as per Godfrey Abwadame, on behalf of the suspended Chief Justice, is going to trigger the committee or the Supreme Court? Why do you think that?
There's two reasons that Dr. as a former Attorney General, was Attorney General during the MPP era, and therefore everyone knows his political leaning, the MPP. Two, he was one of the key persons who supported the nomination and therefore the appointment of Deputy Chief Justice Gertrude Torkornoo. You see, and therefore entering into this legal battle suggests that it is an MPP NDC legal battle, and I say that as far as that picture gets painted, the ordinary Ghanaian citizen would think that it has ceased to be a legal battle, but has now become a political controversy.
Is it merely because? Is it merely because of his?
Behind the scene, and allowed some other, lawyers to represent the Chief Justice. I'll not, have any problem with it. So the problem I have with it is that it is entrenching, the political divide. So it's now clear the lines are drawn. It is NPP, it is NDC. You see, and it was something that started as a legal battle, is now engrossed in a political controversy. Is that good for the nation? It is not good for the nation.
Right. You say it's not good for the nation. Godfrey Adame has said that he's standing in as counsel for her. I mean, he has the right to do that. In fact, he says it is erroneous to think that his role as Torkornoo's lawyer in the injunction application against the probe affects the optics. He disagrees with you. But beyond these optics, there is an issue of an in-camera hearing. Kweku Pencil has shared his thoughts on it. Per the Constitution, my reading of what Professor Azan and others have shared suggests that this is, per the reading, constitutional on the face of it. It's not optional. What do you think of that, the in-camera situation?
It's not optional. It's a constitutional fiat. So it is something, it is a hurdle, that cannot be, crossed. So once the Constitution has stipulated the proceedings, to be in camera, no one, can be taken out of turn and, merely because the person is a Chief Justice, therefore the person can waive. How many ordinary Ghanaians, can waive such right? If you or, let's say, my wife, were to find yourself in this controversy, do you think that you can appear before the committee to suggest to them that, you have decided to waive your right and they will hear you? No. The law is no respecter of persons. The president is subject to the Constitution. The Chief Justice is subject to the Constitution. The whole Ghana is subject to the Constitution. No one is above the Constitution. The Supreme Court is not above the Constitution. Whatever we do must be in consonance with the dictates of the Constitution.
Speaking of that Constitution, we know when the Constitution uses shall, what it means. But at the same time, on the back of the same political context that you've made mention of, that it's become political, NDC, NPP. And again, the context. Does the context matter at all? After all, the law is supposed to be progressive, right? Is it high time we looked at that clause to determine whether people can waive their rights?
Well, you see, that is why over the years, the canons of interpretation, have increased from 2 to now 6. In the past, it was just the literal rule of interpretation. So, the judges will become now embodying constitutional constitution. But they realized that it was not helping. If you take a strict constitutionalist approach, it may not help. They went on to the golden rule, and now they say purposive rule. What is the purpose, of Article 146 is in enacting that the proceedings shall be held in camera. So if the word shall, had been used, there is no other, middle way. It is shall, and, shall is shall. Even though I concede that there may be instances where, the word may be construed. The 125 have, made it quite clear that citizens can, participate in the administration of justice, and we are participating in it. But the same Constitution, says that when it comes to certain matters, such as the one, at hand, the proceedings shall be held in camera. You have no choice. The Chief Justice, has been supervising the administration of justice. There is no situation which will call for a relaxation, of the word shall. This is not one of those situations. She has, boxed herself into a tight corner. These arguments, will not advance, the course of action, any more than what it is already on the ground. And as I said yesterday, I see all these, moves as a ploy to frustrate the committee from proceeding to completion. But these frustrations aside, the judges are human beings. They are being provoked, and they will take it out on all the lawyers who appear before them. So the moment you apply for an injunction order, it will be placed. If I were the Supreme Court, all I would say is that we have made certain pronouncements. Enough is enough. Any new application shall abide by the pronouncements that we have already made. To bring an end, to this endless ping-pong game, you should take that tough stand. Now, the Chief Justice herself is now a litigant. Just once she appears before the court, she's still going to bow before her own junior as a Chief Justice. The buck stops on her deck. Now, she's lowering standards. She's going to appear before the very people she had a hand in appointing, my law, my lady, and all that. People will be, sitting on the bed. They'll be laughing at her without her knowing. And I'm saying that this is not, what we ask for. We did not go, to court to be ridiculed or humiliated. But now that, the stakes are high, by virtue of what she has herself done, it means she has slammed the door behind her. She's taking the key away, even if the petitions succeed. She will find it difficult to reopen the front door to enter.
Just clarify for me, are you saying she's gone beyond the point of return with this interlocutory injunction she's seeking? Has she gone beyond the point of return?
Pardon?
Has she gone beyond the point of return with this latest interlocutory injunction she's seeking?
Sure.
Okay.
Sure.
All right.
She's closed the door.
Okay.
She's closed the door behind her. She cannot enter. When the committee was set up, the president, even though the president closed the door, he left the key hanging. And therefore, whenever the outcome was known and the petition failed, she would, merely, remove the key to open the front door and enter. Now that, she has sued the president, she's not sued the Attorney General, she has sued the president. The only reason why she could not mention the name of the president on the writ is because of the immunity that the Constitution has accorded the president. That is, why she has had to sue, the Attorney General. Otherwise, it's the president she has sued. But if you sue the president, who is, the head of one arm of, or branch of government, and you are also, when you finish and you lose, can you go back? And the state appeal to the good conscience of the president to reconsider his position, even if she wins. How is she going, to? She may go there, and the executive may decide, not to do anything about, the estimates of the judiciary.
Right.
The Chief Justice is constitutionally obliged to submit, the estimates for the judiciary, to the executive, even though the Constitution in Article 127 has suggested that it should go straight, to the Ministry of Finance, for approval. They still have to go through, the executive and then take legislative approval. So the independence, that has been enacted in Article 127, theoretically, yes, but practically, there's some diminution there.
Right.
So the independence, financial independence of the judiciary, since 1992, has remained, on paper. And now that, the Chief Justice of the nation has sued the executive, I don't think that all is going to be well. The relationship, has broke. It has never, ever repaired.
Okay.
Trust me.
Right. Sweetie?
Mr. Ansari, you said that the Chief Justice is going to her colleagues now to plead her case, and they will be laughing at her without her knowing. You also said that these judges are human beings. The Supreme Court has thrown out all her applications seeking to pause or stop the processes. And as we speak, you just also said that she's closed the door behind her. She clearly has no confidence in the people who are going to be listening to her case. And she cited her reasons in that plea. Does it mean that as we speak, there is no way we see the Chief Justice coming back to assume that office? I mean, coming back from that suspension, from where you sit?
I mean, in our local parlance, they will say that she sacked herself. She sacked herself. She has sacked herself. Without her knowing so, she has sacked herself. Now, the objections she's raising, similar or identical objections have been raised in Wilson and Apalu. And if the lady Chief Justice and the lawyers who only care to go and reread Wilson and Apalu, I mean JSC, it will make it quite clear that the rule against judicial bias is not cast in stone.
All right.
Just that the moment you say that there's some bias, then you win. No, there are situations where the presence of disqualifying elements under the rule against judicial bias will not render the adjudicator incompetent to sit. This is the law. This is what NJA made us. So when the Supreme Court spoke by the voice of NJSC in Wilson Apalu, they laid down the threshold. That threshold has ever since remained the rule or the principle.
Okay, Mr. Asasari, let's hear Mr. Penstill's take on the matter as well. Mr. Penstill, so this is what...
I would say that I'm totally shocked by the submissions that have been made by Mr. Asasari. I'm so much shocked. How could the former director of the law school, a teacher of the law, speak the way he
What is the element of shock for you? What did he say exactly that doesn't sit well with you?
That if we're a Chief Justice and you go to court, you have either descended lower, or that if you go to court, your case has been cast out in a way that will not permit the court to weigh and reflect upon the substance of the case, which is the meaning that I'm making out of what he's saying. I mean, and I'm totally surprised that a person's case is made on the basis merely of your position and the fact that, I mean, contrary to his view, she has gone to court to have her matters adjudicated upon as a former Chief Justice, and so what? I'm totally surprised. The impression is that the court makes up its mind not based on the merits of the matter before it, but based on factors which are, in my opinion, very irrelevant, and I don't understand him at all.
So you are hopeful that the Chief Justice has not, in fact, crossed the point of no return?
I'm surprised that he can say that.
No, I'm asking if you are hopeful that the Chief Justice can come back from the suspension.
There's no suggestion, no intimation, no whatever at all to reach that conclusion.
Okay.
Because then what he's saying is that the Supreme Court, they are mindless or what? I don't even understand him. That one should take a... He's not even arguing on the basis of the law.
Mr. Pinto.
On the basis of the law, A, B, or C. He's just saying merely the fact that she's gone before the court and done this and done that. That alone. Come on.
No,
I'm totally surprised.
Okay, let's allow Ansasari to explain himself.
Let him give us the legal basis for his contention. You should express it like that.
So, Mr. Ansasari, let's hear you out in terms of the legal backing for your submissions.
I was saying that I read the legal backing. I said this and that. But the point is that I would like my good brother to appreciate the legal point that there are ways in which the rule against judicial bias which the lady Chief Justice is to rely upon are right. I'm saying that the rule against judicial bias is not something, that is cut in stone, that when you go there and you bundle it will be affairs. No. There are situations where the certain qualifying elements under the rule will simply not render the adjudicator incompetent, to say. So if you are seeking to remove or to have Kwama and Kwame Kwesi moved merely because someone saw them discussing with other persons and all that. That's not what is bound, to aid. So I'm saying that rather than the Chief Justice herself descending into the arena of litigation, she could have allowed other persons to do that. Now, Kweku Pencil knows that the moment the Chief Justice, entered the courtroom, she, unlike the Attorney General, does not have audience in every court. So it is only the court that she has brought, the action that it has. And when she enters that courtroom, they are not going to accord her the dignity of the Chief Justice. That's how they will treat her, as just anyone, ordinary Ghanaian litigant. And I'm also submitting that is not good for the image of the office of the Chief Justice. The office of the Chief Justice is a very, very high, pedestal. The edifice is so strong that it is one of the pillars of our constitutional dispensation in this country. And the head of the judiciary, as enshrined in Article 125, must not be seen to be negating the court and then go back, to a position as Chief Justice. That's the point I'm making.
All right. So let's pause here for a second. Mr. Painstill, so this is what he's saying.
This is a moral argument. This is not a legal argument. I mean, a lawyer, he himself is a teacher of the law, former director of the Ghana School of Law. And he cannot say that for these moral reasons that is given, a Chief Justice or a former Chief Justice must not go to court. The impression is given is that our judges are activated or actuated by moral issues or whatever, and not the law that come before them. We agree that judges are human beings like we are, but let's raise the pedestal a little. Let us know that they
well, so let's hear your legal backing for your counter-argument then, Mr. Painstill.
No, but we go to court for the law to be pronounced. That's the long and short. So somebody who makes an argument that when you go to court, by reason of your position as a Chief Justice or former Chief Justice, you lower the bar and stuff like that, I don't know where the argument comes from.
You may say those are moral arguments, not legal arguments. Well, that is your opinion, obviously. Ansari disagrees with you.
You are trying to suggest that somebody must not activate the law merely because of his former position.
I doubt that is the positioning. I think it's also premised on this. So tell me, there have been 2 interlocutory injunctions applications so far. One on her suspension, the other one on her impeachment as well. Both of them have been thrown out by the Supreme Court. That is a legal argument. How come, and that is the same court that these new matters, including these same points, are going before. Do you get now what Ansari is trying to suggest?
No. You see, you don't make those kind of conclusions. You don't suggest that because this application have been thrown out, every application that comes will follow the same fate. I don't believe in that. It is not how our law operates. A lawyer may only express his view or his opinion based on whatever legal arguments that he has concerning any matter that appears before the court. But that cannot be a reason why someone cannot mount any action for any good reason. You may only express your view about the matter, but don't reach those conclusive points to suggest that if you follow this path also you will lose. If at the very best, it may be your opinion. And that's it.
So
that's it.
We have a president in this country, we have a president where a former justice of the Supreme Court sued another judge of the Superior Court. I'm referring to the case of Yawadade and Teresa Kote Amata. And the Judicial Council in that, I think 1992 or so, descended severely on the Justice Adade that he had mustered the courage to sue a fellow judge. So they referred, in that case, to the judicial immunity of judges, and the Adade was admonished, and the advice that was given was that as judges, as sitting judges, they should be the first and the last to go to court. So if a good person, a good friend, seeks to know, I've referred to the Yawadade, and that is the precedent. Now, if Yawadade at that time was an acting chief justice, He was the acting chief justice when he issued Teresa Masafuti, and the Judicial Council frowned upon it. Now here we are having the substantive chief justice doing a committee set up by the president in consultation with the Council of Chiefs. And I'm saying that tactically it's a very unwise step to take.
Okay. Gentlemen, I want to leave you, at least from my end, with these thoughts. I'll start with you, Kweku Painso. The suspended Chief Justice wants her suspension suspended. She wants some justices of the Apex Court disqualified from sitting on the matter, including Justices Wamang and Adibu Asiedu. And she cites that one of them sat on a case, one of the injunction applications that she had brought. Another one also ruled in favor of one of the petitioners in the past. The case of Justice Gayu, when the Chief Justice was still not suspended, comes to the fray. And she goes beyond that through Godfred Dame to suggest that the committee itself, the lay members, should also go, and that, to effect, the committee's work should come to a grinding halt. With all these reliefs and approaches, what realistically do you think would happen in the Apex Court, looking at these reliefs that have been sought? And that is the same question for you, Mr. Ansasari.
I can already see that 2 rulings have already been given, all of which have gone against her. It would appear to me that the instant application referred to carry more or less the same theme. In other words, the attempt to, get the Chief Justice, the President's suspension of her set aside. And sometimes, looking at the trends, a lawyer may conclude that they may reach the same conclusion as they reached in the first 2 instances. But let me put it this way, that when we go to court, we want something to serve as a record that may guide the future. So when a matter has been tried over and over, we will all come to some conclusion that this is the way the judges have reacted or acted upon this type of complaint. And there can never be anything wrong with it. But I would say that once those applications have been filed, let us hear what the Supreme Court will say. Even if we suspect or believe or reckon that on the basis of the 2 earlier rulings, they may reach the same conclusion. That's all that I want to say.
All right. Mr. Ansasari.
Okay, thank you very much. I would say that first, the CJ's action is, I'll describe that as, one of the bad behaviors for which the Judicial Council was, set up, to always ensure that the Chief Justice, will not, behave herself badly. Secondly, the law of karma. I'm glad you mentioned the Gao case. And Sadio Sorry urged on the Supreme Court differently constitute in the Speaker's declaration of authority case. The Chief Justice, said, what about Puama? She said that now she finds herself going back to, eat, her humble pie. So if she says that, it is unwise for the president to empanel Puama and Etedu, I can only say that it's the law of karma working. That's all that I can say.
Gentlemen, thank you for your time. I mean, you're both legal analysts, and these analyses for me raise questions about the independence of the judiciary and the executive authority and the 1990 Constitution. But this is where we are. So what's the best case scenario and worst case scenario now that the applications have been thrown out by the Supreme Court? That's my final question. Mr. Kweku Painso. I think we've lost all our guests. Well, Kweku Painso is a private legal practitioner, and Kweku Ansasari is former director, Ghana School of Law School, and they joined us. And if